Right, you'll recall that yesterday on Newzroom Afrika we spoke to Advocate Dalimpofu, who was, as part of the Pan-African Bar Association of South Africa, said that they had some major reservations about the legality of the JSC interviews for prospective judges. But this organization is not the only one that's raised issues. Let's get the view now from Freedom Under Law research consultant Chris Oxtoby. Pardon me. Welcome. Thanks for joining us on Newzroom Afrika. Several bodies have taken up issues with the decisions made about the vacancies and the manner in which the JSC interviews have been conducted. What's been your assessment?
So I think it's a trend that people who watch the JSC interviews over time notice is that the higher up the court hierarchy the positions are that are being considered, the more controversial the interviews tend to become. I think if one took the Supreme Court of Appeal interviews that we saw at the beginning of the week out of the equation, we would have probably given this week's round of interviews a pass and said that there were things that needed to be improved, but that many aspects of the process worked quite well and showed some signs of improvement. But of course, what's very much dominating everyone's attention is what happened in the Supreme Court of Appeal interviews. So that's positions on South Africa's second highest courts. This is obviously a particularly significant and important court. And many people are really puzzled and confused about why one of the country's, I think, widely recognized and accepted as one of the country's leading lawyers in Judge David Unhalter was not appointed, when the JSC at the same time, in fact, left 2 of the 4 vacancies open and yet didn't appoint a highly celebrated and highly respected judge to that position. So this is obviously raising some very fundamental questions about the process that is going into the JSC's ultimate decision-making and what is it informing its decisions about who to put forward for appointment, even if the actual process and procedure during the interviews themselves may be running better than it has done in the recent past.
Yeah. The rejection of Judge Unhalter, I mean, he's no stranger to the Commission, having unsuccessfully interviewed for the Constitutional Court on at least 2 occasions. I mean, he's been constantly overlooked. Why do you think he perhaps seems to not be the right fit or the right candidate for the post?
Well, that's the million-dollar question, and that is exactly the issue that everyone is trying to disentangle. I mean, it is important to recognise that there have been some issues and concerns that were raised during the past interviews. There was an issue when he appeared last year for the Constitutional Court, where a question came up about a situation where he had sat on a panel of judges considering an application. Not in a full court hearing, but considering a petition for leave to appeal when he was acting at the Supreme Court of Appeal. And then he, on his version, mistakenly, without realizing, sat in a panel of Constitutional Court judges to consider an appeal on the same matter. And that was an issue that was raised last year. It came up again this year, and there was a lot of to and fro. And I think many people looking at that exchange thought that he was perhaps being unduly technical and unduly legalistic in how he was approaching that situation. But I think if one takes a step back, it's really not an incident that I would think provides justification for saying that he is completely unappointable to the court at all. And one can accept that people might differ or disagree with the explanation he gave. But to elevate that incident to the level of an issue that is sufficient to actually disqualify him from appointment to the SCA at all is something that I really struggle to wrap my head around, and I think everyone who watched the interview process is really struggling to wrap their head around. So look, we will have to see what comes out. Of course, in the normal process, the JSC doesn't announce its reasons for why it's made a decision, and the Council for the Advancement of the South African Constitution has formally requested those reasons from the JSC for the entire SCA round. And I think that's a very important step to have taken, because we do need to get some insight into what actually went into that decision-making process from the JSC. So we'll wait to see what comes out of that. But on the face of it, just from looking at the interviews and from looking at the candidate's track record, it's very surprising, particularly that Judge Unhalter was overlooked. And it's also frankly surprising that at least one of the two other vacancies wasn't filled as well, because there were other candidates who I think performed credibly in their interviews and were also omitted. And the court really does need permanent judges in that position for its own institutional capacity to enable it to do the work that it needs to do. So it's a broader problem than beyond the individuals in question missing out. The court needs those kind of people in those positions to do its work.
And what impact will this have? Will this decision, the two vacant posts, have on the day-to-day runnings of the court, and perhaps the problems it may begin to bring up? Because yes, CASEC has also written to the JSC requesting written reasons why it only recommended the two candidates for the Supreme Court of Appeal and leaving those posts vacant.
So what will happen practically to fill that gap is that the court will bring in what are called acting judges. So those are judges that are not permanently appointed to the court, but who serve temporarily on the court to fill those spaces. So it won't be a case that there's absolutely nobody there to do the work. Okay. But the problem with acting appointments is that the people are only there for a temporary period of time. They're not necessarily as experienced and immersed in the court's work. And it's something that is quite controversial for several reasons, both from a consistency or continuity point of view, but also because the process for appointing an acting judge is different to the process for appointing a permanent judge. They don't go through the Judicial Service Commission process. So some jurisdictions just don't allow it at all in their higher courts. So it is an issue that is a cause for some concern. It's a far from ideal situation. It's really a temporary stopgap, and one that ideally one would avoid having at all, which is again part of what makes the decision to leave these two vacancies open problematic.
Very well. Thank you so much. Thanks for weighing in. Freedom Under Law Research Consultant Chris Oxtoby speaking there about some of the interviews, the JSC interviews, and of course giving their view as Freedom Under Law.